the first day of our summit, and the point of this discussion will be investigation and prosecution of wartime environmental damage. And the moderator of this discussion is Maxim Popov, advisor to the Prosecutor General. I'm giving the floor to him, and he will introduce other participants of this discussion. Maxim, please.
Thank you so much. Dear ladies and gentlemen, dear participant of United for Justice, United for Nature conference, it's a great privilege for me to moderate this really important plenary session, and I would like to express my gratitude to all of you who came here and express your interest in this topic. I believe I can label all of you as justice-addicted people, justice-addicted for nature. So, before I will present the speakers, I would like to stress your attention that Ukraine is pioneering direction of prosecution of conflict-related environmental damage, and we intend to be the first country in the world who will bring to justice those who are responsible for the devastating consequences for our environment on behalf of Russia Federation. And this panel will be dedicated to the first pillar of accountability, pillar of individual criminal responsibility. I would like to present excellent speakers in our panel. So we have here Victoria Litvinova. She is a deputy of the Prosecutor General of Ukraine. She is responsible for the most vulnerable victims of this war in our office, for the children and for the environment. The second speaker we have on the panel is Brenda Hollis. She is principal trial lawyer of the Office of the Prosecutor of the International Criminal Court. Richard Rogers is executive director of the Climate Council and is being involved with this work with the Prosecutor General Office over a year already. Please. And Wayne Jordash is the president of Global Rights Compliance, who is also engaged in advising and helping Prosecutor General Office in all of our accountability efforts. Just to express my gratitude to you, I will announce that after we will have the first round of speeches of the honorable speakers here, I will grant the opportunity for you to ask the questions to the speakers here. And I hope that we will have some kind of interaction. So if you will be willing to ask the question, please then raise your hand and you will be provided with the mic. Thank you so much. So for the beginning, I would like to propose the floor to Victoria Litvinova, who I hope will tell you about the work of the Prosecutor General Office and the Specialized Environmental Prosecutor's Office of the PGO in this important topic. Victoria, please, the floor is yours.
Дуже дякую. Шановний Максиме, шановні учасники панелі та шановна аудиторія, я почну із цитати. Навколишнє середовище – це не абстракція. Воно являє собою життєвий простір, якість життя та саме людей, в тому числі ненароджених поколінь.
This quote from the advisory opinion of the International Court of Justice sums up the great significance attached to the protection of the environment, which is not limited to single states, but has a long-term effect on the whole mankind. Today, no one doubts that environmental impacts of armed conflicts, wars, and military aggressions can result in multifaceted, large-scale, severe, long-lasting, and mostly irreversible damage. The existing international legal framework provides for direct and indirect protection of the environment in time of war. To a certain extent, based on international humanitarian law instruments such as the additional protocol to the Geneva Conventions of 1949 relating to the protection of victims of international armed conflicts and UN Convention on the Prohibition of Military or any other hostile use of environment modification techniques. But what has been lacking so far in state practice, both on international and national level, is the criminal dimension of justice, prosecution of and conviction for environmental harm. There is a number of reasons as to why it is so, but I believe it could be a matter of a separate panel discussion, and we shall rather focus on how to prosecute environmental harm in armed conflict and how to investigate it before that, and more specifically, how to do that in Ukraine. Undoubtedly, the war of aggression initiated and waged by Russia against Ukraine is one of the most brutal and, at the same time, heavily weaponized armed conflict in European history. It's even more devastating when taking place in urban settings. From a practical point of view, it means that the used weapons or their remnants can release toxic chemicals or harmful materials, leading to contamination of the environment, degradation of soil and water. At the same time, environmental damage is being caused by large-scale fires in forests, oil storage areas, in warehouses of household chemicals, in large supermarkets, explosions of ammonia and gas storage facilities, destruction of containers with dangerous substances, flooding of ships and mines, etc. The extent of harm often largely depends on duration, intensity, and missions of respective military operation. If we generalize, during an armed conflict, an environmental harm may result from direct attacks against natural environment such as forests, fresh waters, and marine environment. Secondly, attacks on civilian sites causing consequential indirect damage to the environment. It includes attacks on civilian sites such as food warehouses, grain supplies, attacks against a potentially dual object like depots, and attacks against works and installation containing dangerous substances. And third, as a result of pillage, destruction, or seizure of assets of the natural resources. Such incidents have been observed from the early days of the war, and they continue until now. Therefore, we have to make sure that Russia and individual perpetrators are held to account for the environmental damage caused during the armed conflict in accordance with the international law standards. There are three options for related criminal proceedings: national jurisdiction of Ukraine, International Criminal Court, and third states' national forums based on universal jurisdiction principle. As a Deputy Prosecutor General, I will address the first option, as I believe our dear friend Branda, present here, will address the issue of prosecution of the environmental crimes by ICC. Let me also make a preliminary observation which I believe is relevant for our discussion. International crimes are complex by nature per se, and we Ukrainians know it better than anyone else because we are in fact investigating thousands of such incidents. International environmental crimes have an additional layer of complexity due to evidentiary peculiarities of environmental damage and the need to address accountability of multiple perpetrators in the chain of command with varying levels of responsibility. Because of the lack of national practice and international case law, Ukraine, for the first time in world history, is attempting to prosecute attacks on the environment as war crimes. This brings us to the current point of discussion: how Ukraine can prosecute environmental crimes committed during the armed conflict in accordance with its national criminal law. We have two routes that could, in certain circumstances, be mutually complementary. As a war crime under Article 438 of the Criminal Code of Ukraine, and as a crime of ecocide under Article 441 of the Criminal Code of Ukraine. Article 438 of the Criminal Code of Ukraine lists some of the war crimes with an open-ended formulation, criminalizing laws and customs of war, provided for in treaties recognized by Verkhovna Rada. In our understanding, it includes grave breaches of the four Geneva Conventions and of the Additional Protocol number 1, as well as serious violations of the laws and customs of war that protect important values, involve grave consequences for the victims, and also stem from treaties that are in force for Ukraine. In addition, the Criminal Code of Ukraine penalizes mass destruction of flora and fauna, poisoning of air or water resources, and any other actions that may cause an environmental disaster. The threshold criteria for application of this article would be ecological disaster, interpreted in line with the principle of legality, relevant IHL treaty provisions, and INMOD Convention. There has been no practice related to application of the crime of ecocide in Ukraine or a number of countries with similar provisions in their laws, including Russian Federation. Similarly, at the international level, there is no standalone international crime of ecocide, and its potential scope is currently debated by experts. Therefore, Ukraine is the first state that initiated investigations into the crime of ecocide in the situation of an armed conflict. We have opened investigations in more than 200 cases for environmental war crimes and over 10 such cases for the crimes of ecocide. We could divide these cases into the following groups: attacks on and destruction of works and installations containing dangerous forces, such as NPPs, nuclear and radiation facilities, dams, HPPs, etc. Attacks against petrochemical and civil energy infrastructure, illegal extraction in occupied territories resulting in environmental damage, etc. Let me also use this opportunity to express gratitude to our team of international legal advisors, forensic experts, and environmental scientists for their support and assistance in our work. We are grateful for the legal and technical advice, as well as for the capacity-building activities, as well as in the development of the prosecution strategy. And let me now briefly address some practical aspects of investigation and prosecution for environmental crimes. I'll quote two examples: destruction of Kakhovka Dam and shelling of the nutrient source facility in Kharkiv. On the 6th of June of this year, the armed forces of Russia ruined the Kakhovka hydroelectric plant, which resulted in leakage of water and flooding of settlements in the Kherson region. The flooded area is 610 square kilometers, including 80 settlements. 35 people were declared dead.
Apart from having significant ramification for livelihood of civilians living in the region, it has resulted in an extensive harm to biodiversity of coastal areas, aquatic ecosystems, etc. The land flooding continues to lead to soil degradation, along with an ongoing destruction of national parks, pollution of waters, and it endangers up to hundreds of species of plants and animals. In addition, the destruction of the Kakhovka Dam poses a significant threat to the operation of the Zaporizhzhia nuclear power plant, which has been occupied by Russia since March of 2022. The continuing potential consequences of the destruction call for unique solutions and approaches. So we were forced to set up the National Investigative Team of experts, comprising 172 prosecutors and 285 investigators. We are also closely cooperating with the International Criminal Court, and their team have visited Kherson Oblast in June of this year. The Kakhovka dam case has demonstrated the need for complex and specialized expertise on the long-lasting effects of the incident and its impact on various aspects of the natural environment. It is a challenging and demanding task, since we are estimating the systemic understanding of the risks and challenges resulting from the dam's destruction. The second case pertains to the periodic shelling of the research center of the atomic industry and nuclear energy of Ukraine, called Kharkiv Physical and Technical Institute. Specifically, its nuclear subcritical installation in the neutron source, along with the storage of nuclear materials. The neutron source facility is a civilian object that contains a dangerous force. And since the beginning of the full-scale invasion, no Ukrainian armed forces have been deployed in the vicinity of the site precisely to avoid it becoming a legitimate target of an attack. Information regarding the institute and the neutron facility is publicly available on several websites. Thus, it cannot be argued that Russia did not have information regarding the potential threat posed by any damage to the facility. The neutron source facility has been attacked with 74 different types of weapon, including aviation bombs, MLRS systems, and artillery. We are lucky that despite the shelling of the neutron source facility and the storage building, the installation itself and nuclear materials, fresh nuclear fuel, were not impacted, as the concrete building managed to survive the attack. Otherwise, we could have been facing consequences of contamination of the environment with nuclear waste and the effect of the radiation that undoubtedly could lead to widespread, long-term, and severe impact on natural environment. Investigation of this case is complex, since it involves the aspect of identifying targeting procedures, so examining the weapon systems and the artillery that were used by the Russian armed forces. We need to identify the entire chain of command, along with identifying the commander in charge for making this decision, and also we need to obtain qualified expertise that could define the parameters for the widespread, long-term, and severe damage to the environment. The latter aspect is challenging, since there is no practice or cases that could be replicated in Ukraine. As of now, the pretrial investigation has already identified the commander of the Western Military District of the Armed Forces of the Russian Federation that was involved, along with 5 of his subordinates, in this operation. And we are planning to serve the indictment and war crimes and the crime of ecocide to him, according to the Criminal Code of Ukraine. To sum up, I can say that the investigation and prosecution of environmental war crimes requires high technical capabilities and the use of complex scientific data. It requires timely access to crime scenes, together with international environmental experts. And for sure, the main challenge that we face is the lack of case law, either in Ukraine or worldwide. Last but not least, continuous assistance and support from our international partners is crucial to us, because to succeed in our quest for justice and accountability for environmental crimes is only possible through national proceedings, accountability in the ICC, and investigations by third-party countries. Moreover, we need to raise awareness on the damage that is caused to the environment of Ukraine, and we need to promote the adoption of the international crime of ecocide and strengthening of international mechanisms for accountability. Thank you so much for your attention.
Thank you so much, Victoria, for this detailed overview of the work which are being taken right now by the Prosecutor General Office. And now I would like to pass the floor to Richard Rogers and actually ask what are actually legal avenues we have from the perspective of international humanitarian law and international criminal law for the prosecution of the conflict-related environmental damage. Richard, please, floor is yours.
Yes, thank you, Maxime. Does my microphone work?
It seems to me it doesn't. Could you please take this one, this mic? Yes, it should work.
Is this working?
Do you hear Richard?
Turn on.
Is this working?
Yes.
Thanks, Maxime. I'm running out of hands. So I've been asked to cover the legal framing for environmental war crimes. And what this really means is looking at the laws that might be applied to particular factual scenarios. And that's necessary to understand the legal elements that need to be proven. And so it will help inform the investigations in the field, the charging in the indictment, and ultimately the prosecution in court. So what do we mean by environmental war crimes? Well, this is a very common question that people ask, and that's understandable because there is no strict legal definition. There is no easy list. In fact, it's just a way to describe war crimes that ultimately result in serious harm to the natural environment. And that can include direct attacks against the environment. So, for example, intentionally targeting a forest and burning it down, or polluting a river. It might be attacks against other types of civilian structures that cause consequential harm to the natural environment. So the bombing of dams, nuclear facilities, food storage warehouses, etc. It can also include pillage and appropriation of natural resources in occupied zones. So an occupier can't just steal the natural resources and take them home. In Crimea, for example, the Russians have dredged a lot of Ukrainian sand to build the Kerch Bridge. And fourthly, it might be the use of prohibited weapons, chemical weapons, certain types of poisons, which will, in many cases, lead to environmental harm. So almost all the cases that we look at will fit somewhere within one of those four broad categories. As you've probably gathered, environmental war crimes is a novel area. It's never been prosecuted before, not at the tribunals for Yugoslavia or Rwanda, not at the ICC, and not in national courts either. All those war crimes cases have focused on direct human harm. So that novelty presents both challenges and also opportunities. So in terms of the challenges, there's no direct legal precedence. So for example, we don't know how terms like severe or widespread harm will be interpreted by the court. There's no direct expertise, so we can't phone up prosecutors who have investigated and prosecuted these crimes before. The Prosecutor General in Ukraine pretty much has to figure all this out for himself, using lessons learned from other types of war crimes prosecutions. But there's also great opportunities. So if Ukraine does the heavy lifting at this point, then they will show how environmental war crimes can be investigated and prosecuted, and that will help future prosecutors in other cases, in other places. And another opportunity is to show why they should be prosecuted, not least to explain the role of the environment in post-conflict recovery. So when peace returns, people need to grow crops, they need to catch fish, they need to walk in nature, and all that means that the environment really does deserve protection. In 1996, almost 30 years ago, the ICRC published its first guidelines on the protection of the natural environment in times of armed conflict. And that was a detailed and comprehensive and very well considered examination of the state of the law at that time. And in its foreword, an ICRC expert, Antoine Bouvier, said, "Existing law, if properly implemented and respected, provides adequate protection to the natural environment." And he added that better implementation of existing international obligations is thus the main issue. So to put it simply, we have the laws, we just need to use them. And since that time, IHL's rather elaborate regime of protection has laid dormant and unused. That's until recently when, of course, the Ukrainian Prosecutor General has decided to grab the torch and to run with it. So the regime basically offers two tiers of protection which cover all the factual scenarios that I mentioned earlier. There are general protections, so there's several provisions that covering various scenarios, and there's a specific protection that looks at very severe harm, the widespread long-term and severe damage to the natural environment. And all those can be applied via Article 438 of the Ukrainian Code. And that ultimately allows Ukrainian prosecutors to use all the laws that are contained in Article 8 of the Rome Statute, with some tweaks here and there. So key to understanding the general protection is this, that the key purpose of international humanitarian law is to protect civilians and civilian objects. And under international humanitarian law, the natural environment is presumed to be a civilian object. So it has the same protection as a school, as shops, as apartment blocks. And there are basically four categories of this general protection. Firstly, the protection that flows from general principles protecting civilian objects. So principles of distinction, precaution, and proportionality. So you can't directly target the natural environment. You have to be cautious and spare the environment during any military operations. And where incidental harm can't be avoided, it can't be excessive in relation to the military advantage. Secondly, we have general protection relating to enemy property. So, as a general rule, Russia can't pillage, expropriate, or destroy Ukraine's nature in the parts that it occupies or controls. Thirdly, we have special protections relating to facilities containing dangerous substances, dams, nuclear facilities, and also important cultural objects. So Russia can't bomb the dams, it can't destroy sacred mountains, for example. And finally, we have prohibited weapons, which obviously, if they're used, are very likely to cause environmental damage. So the combination of all those categories already provides a very comprehensive regime of protection. But the drafters of the additional protocol also foresaw much more extreme cases, and this is where widespread long-term and severe damage comes in. Scenarios like the use of Agent Orange during the Vietnam War, And this is the provision that people tend to focus on when they first start to think about environmental damage. And that's because it's the only explicit reference to the environment in additional protocol or in the Rome Statute. But really, it's only one of many options, and probably the one, hopefully the one, that is used the least. Now, as we've heard, in addition to IHL, we also have a national crime of ecocide that can be used. The mass destruction of flora and fauna, poisoning of air and water resources, and also any other actions that may cause an environmental disaster. Now, ecocide laws are found in many former Soviet states. It's also in the Russian code. But there's no examples, at least none that we have found, where it's ever been used, and so there's no case law. So we don't yet know how that language might be interpreted and what legal elements might be applied. It's potentially very useful, not least because it has very important symbolic value. But the application of any national crime in situation of armed conflict also attracts special rules. So the prosecution will need to contend with the principle of combatant immunity, which in a nutshell basically says that if an act of conflict is not prohibited under international humanitarian law, then you may not be able to prosecute that under a domestic crime. So just to finish, with no real precedent for prosecuting environmental war crimes, the first hurdle was always going to be finding prosecutors who understand the importance of the natural environment and are willing to take the plunge and use their precious resources to do something novel. I think it's fair to say that that hurdle has definitely been cleared. The Prosecutor General, Victoria, the SEPA prosecutors, Maxim, have dedicated much time and effort into investigating all the terrible crimes that you've heard about. And it's their efforts that will not only benefit Ukraine, but also many other countries who also suffer environmental harm during conflict. Thank you very much.
Thank you so much, Richard.
Дякуємо, Річарде,
Legal framing of environmental war crimes.
за таку
On one hand, it's
докладну
inspiring that we
промову.
have
З одного
different
боку,
legal
нас
avenues
надихає
to
те, що
prosecute
є
these
чимало
crimes. On
можливих
the other
правових
hand,
підходів
the
до
challenges
переслідування
are really
цих злочинів.
huge.
З іншого боку,
I would like to
виклики
pass the floor
справді
to Wayne
великі.
George, since the Global
Я
Rights
передаю
Compliance
слово
has
Вейну
mobile
Джордашу,
justice team,
оскільки
and they are
у
usually
його
involved in the
організації
field
є
work. And I
мобільні
wanted to ask
команди,
Wayne,
які
are there any
ведуть
other
польову
specific,
роботу. Я хотів би запитати
challenges
про
when
якісь
it comes to the
інші
prosecuting and
виклики.
investigating environmental war crime itself?
Thank you very much, Maxim, and thank you to the OPG for, excuse me, inviting me to speak on this important panel. I've been asked to, as Maxim has just said, develop the question of what the challenges are in investigating and prosecuting this kind of harm. Let me start with an ICRC quote. In 1987, the ICRC, in a sense, foreshadowed where we are in Ukraine today and asked the question, threatened at all times by natural disasters such as drought or human scourges such as pollution, what would become of mankind if in time of conflict, willful destruction resulting from man's ruinous actions were added to all of this? And sadly, this is where we are in Ukraine today. Putting aside the damage done from 2014 in Crimea and in the east, in only 18 months, as we've heard, the Russian invasion has wreaked massive damage and destruction on Ukraine's environment. 50 years after that comment or question from the ICRC, Russia's ruinous actions have been added to the ever-growing list of atrocities perpetrated against Ukraine and its people. However, as you've also heard from Victoria and from Richard, hopefully these actions will not be without a clear answer. As you've heard, a legal framework exists that can be used to hold perpetrators to account, and it's rooted both in national law and international law. And by the looks of this hall, there is also political and prosecutorial will to actually, eventually, and at long last, activate this law and use it to investigate and prosecute those men and women who have done so much harm to Ukraine's environment. But challenges remain, and you've heard Victoria and Richard discuss some of them. The road to hell is paved with good intentions, and investigating and prosecuting, in essence, a new crime is always difficult. Now, of course, it's not a new crime because it's existed, as we've heard, for some time, but it's never been used. Law has been allowed to lie dormant. Law is never useful until it's used. That's the reality. And it's used in a courtroom, not just in mechanisms outside of courtrooms. Of course, we know that international mechanisms have been created over the last years. We know that the United Nations had a compensation commission which was developed for adjudicating harm done by Saddam Hussein's illegal invasion and occupation of Kuwait in 1990 and 1991. The Eritrean Ethiopian Claims Commission looked at Ethiopia's bombing of Eritrea's reservoirs and recognized that Article 54 of Protocol 1, Additional Protocol 1, that is the prohibition on destroying objects indispensable for the survival of the civilian population, was part of customary international law. We know the ICJ has also ruled on pillage by Ugandan forces. And we understand, of course, that the ICC exists and other UN mechanisms exist. And as you can see from the slide, we have seen this movement in international law to at least talk about and to some degree adjudicate environmental harm. But these are not prosecutions and trials, and this is a fundamental problem. Law needs to be used, it needs to be clarified and developed. We only know that it's fit for purpose when trials occur and when convictions or acquittals happen. Judges need to wrestle with the law. They need to determine what the precise elements mean, what the acts which constitute crimes are, and what the omissions which constitute crimes are. Prosecutors and defense need to argue, victims need to plead. Law that lays dormant remains unknown. A blunt instrument at best, at worst, a theoretical possibility. And this is true of all law. This is not environmental law. 25 years ago, we were in the same position when it came to conflict-related sexual violence. It wasn't taken very seriously, even at international tribunals. The law was there, but it needed to be clarified and it needed to be developed. 1998, Akiesu, a trial judgment at the ICTR, now considered to be a landmark judgment. It clarified that acts of sexual violence could be a crime against humanity and could be an element of genocide. But that was a judgment which was almost not to be. When Akiesu was first charged in 1996, the 12-count indictment did not include any charges for sexual violence, despite the fact that NGOs working on the ground had documented widespread rape during the genocide. It's quite astonishing when you think about it now, when you think about how widespread and systematic the sexual violence was during the genocide in Rwanda, and yet prosecutors were not prosecuting it. Not until the pressure mounted on them because of NGOs who lobbied to have sexual violence charges included in the indictment. And of course, one landmark judgment does not make a body of law. It does not clarify the law. What happened at the tribunals thereafter, at the ICTY, at the Special Court for Sierra Leone, at the ICC, was the law is progressively developed. Arguments between cases, arguments between judges, rulings by appeal judges, and so on and so forth. And that's important not just to clarify elements, but it's also important because it tells investigators what it is they should be looking for, how it is to investigate, for example, in CRSV, to investigate in a victim-centered way, how to gather the evidence, how to overcome practical challenges, how to prove the elements, how to respect fundamental fair trial rights when investigating and prosecuting the crime. And here is the fundamental challenge that Ukraine faces now. The progressive development of the law and the practice has barely begun with regard to conflict-related environmental harm. And this is a problem. It's a real challenge. Investigators and prosecutors worldwide do not have the institutional knowledge of how to do this. They, and particularly the Ukrainian prosecutors, have to inch forward, feeling their way without case precedents, without court practice, without lessons learned. This is the fundamental challenge. Ukraine has to lead the way. And it will not be easy, because that, of course, is just the fundamental challenge. Challenges exist from investigation through to prosecution. Proving environmental damage. In many war crimes, you prove damage, unfortunately, by measuring the death of a civilian, injury to civilians. Here, you have to determine the extent of the damage across hundreds of kilometers, maybe thousands of kilometers, maybe outside of Ukraine, not just in Ukraine. The scale, the means of commission, causation, the nature of the crime, and of course, the mental element. More than most war crimes, science is critical and complex in environmental harm cases. Science, in fact, lies at the heart of assessing the damage in these cases. Witness statements, photographs, videos, high-resolution satellite imagery are all vital but not sufficient. Science is where many of the answers will be found, not only to assess the damage now and in the future, but how grave the crime is, what the punishment should be, but also to assess the very content of the crime. And it goes without saying, as Victoria mentioned, that this requires access to the territory. Much of the damage is still in occupied territory. Nearly half of Ukraine's national parks are located in active military zones, with daily shelling or in need of demining. How do you measure scale? How does one measure the full extent of the direct and indirect harm caused by the Kakhovka Dam attack, or attacks on the Zaporizhzhia nuclear power plant? How far do we look? What's the methodology we use? How do we measure it? How many forensic labs do we need? Which forensic experts do we need? How many scientists? How do we measure future risk? How far into the future must we look? How much can science even tell us about the damage and the risk of future damage? And what will a future tribunal of judges see in all of this? And causation. Causation, of course, plays its part in all war crimes. But causation in these kinds of crimes is particularly tricky. Science, again, is critical, but we must travel across complex chains of reaction. Look at the Kakhovka Dam. The initial damage is obvious, the destruction of the dam and subsequent flooding. But what about the chain reaction, the flooding, the release of harmful chemicals, the saturation of soil, air, and water, and the eventual pollution of the food chain and the water supply? Unlike many war crimes, causation does not stop at the point of contact. And how do we disentangle multiple contributory harms? Climate change, ordinary pollution, and so on and so forth. And proving the nature of the crime. Let me take, for example, a disproportionate attack, an allegation of. Prosecutors need not to only establish the weapon system used, but they must gain a granular view of the crime scene, often multiple crime scenes, to show that the damage to the natural environment was disproportionate to the military advantage anticipated. Again, that requires science, control samples, chemical analysis, search for microorganisms, and so on and so forth, and the equally demanding requirement of showing what was foreseen by the alleged perpetrator. And this, of course, leads us to the most complicated issue, the thorny problem of proving intent. Environmental war crimes require an intentional attack and knowledge that the damage would result. That may be simple in cases such as the attack on the Kakhovka Dam, but what about the accidental release of chemicals, or the heartbreaking death of thousands of dolphins washed up from the Black Sea, dying from mines and sonar from Russian vessels? How to establish the relevant state of mind? Was it the perpetrator's purpose? Was it a virtually certain consequence of their actions? Or were they reckless, or negligent. This goes to the heart of 438, and they don't have, unfortunately, the Ukrainian prosecutors do not have guidance on that. Unlike many war crimes, 438 cannot draw upon any rich jurisprudence. So we're at the beginning of a long journey. Challenges remain, huge challenges. Of course, that doesn't mean to say we shouldn't try. We have to try, and we have to make sure that, like CRSV, when we look back in 20 years' time, we have a rich layer of jurisprudence, and environmental harm is no longer something that can be ignored by investigators, prosecutors worldwide. Thank you very much.
Thank you so much, Wayne. It has appeared that we have more challenges than I believed before this actually plenary session, but I hope that we will overcome all of them. And now I would like to pass the floor to Brenda Hollis. We actually have unique opportunity to ask directly the representative of the Office of the Prosecutor of International Criminal Court, who already did a great job and labeled Mr. Putin as a war criminal for the deportation of our children. And we do really believe that ICC will also and I do really believe that ICC will be also instrumental and not silent to the environment as a silent victim of war, of the armed conflict. Brenda, please, the floor is yours.
Thank you very much. I was in the military for 22 years. And while I was in the military, very often my superiors would tell me that challenges were really opportunities to excel. So it's clear from what we've heard today that we have many opportunities to excel in advancing accountability for environmental damage. Let me say that the thoughts I share with you today are based on my experience and my understanding of international criminal law, and do not necessarily reflect the official position of Prosecutor Khan or the Office of the Prosecutor. I find it very encouraging to see all of the initiatives that are currently being enacted to finally respond to environmental damage that is caused by the way parties conduct armed conflict. The mandate of my office is to impartially and independently investigate alleged crimes that fall within the jurisdiction of our court that were committed in Ukraine. As with all prosecutor offices, my office only proceeds when we can make good faith arguments that the law and the relevant, credible evidence supports the charges we are proposing to the court, and that the gravity or seriousness of the harm caused meets the court's requirements for proceeding with the case. In addition, the ICC is a court of last resort, and as such, complementarity with domestic investigations and prosecutions is a core principle to which we adhere. So we act complementary to the investigative and prosecutorial efforts of Ukraine, not in competition with them. And this requires close cooperation with the Office of the Prosecutor General, and I'm very pleased to say we have enjoyed that close cooperation since May of last year when we began our investigations in Ukraine. We, of course, operate within the legal framework of the Rome Statute. And the Rome Statute does not set out environmental crimes per se. However, under war crimes, Article 8, one of the crimes does include as a war crime intentionally launching an attack knowing the attack will cause widespread, long-term, and severe environmental damage, clearly excessive to the anticipated military advantage to be gained. Now, to my knowledge, this article has not yet been the basis of any charges at the ICC. So proof of the crime requires proof that the attack was intentional, That is, it was not accidental, it was not a missed legitimate target, but rather the launch of this attack was intended, and that it was launched with the knowledge that it would cause excessive damage. Then there is a proportionality test that must be met. Would this damage be proportionate to the military advantage that the party believes it will gain by launching this attack? So you can see that there are very high thresholds to be met in putting forward this crime as a charge against an individual. And the court would, of course, have to determine if these high thresholds were met to the applicable standard of proof. The court would also have to determine what degree of environmental harm qualifies as widespread, long-term, and severe. And in addition, the court would have to determine if indeed all three of those are required. The plain language seemed to indicate that yes, you must have widespread and long-term and severe. Is that necessarily true? If you had very severe damage that was short-term and not widespread, but had an incredibly detrimental impact on the human population or the environment, would that qualify? That would require further research both by the court and by the parties to this litigation. In addition to this crime, which seems to more directly speak to environmental damage, in my view, there are other crimes listed in the Rome Statute that could revolve around evidence of environmental harm. For example, if we look again at Article 8, there is a crime which prohibits intentional attacks against the civilian population or individual civilians. In this instance, the court would have to decide if intentional attacks causing environmental harm, which in turn harmed the civilian population or individuals, would constitute an attack on the civilian population. Again, we'd have to break that down into the components and have legal arguments on whether such an attack would constitute this crime. The court would also have to determine what proportion of the civilian population must be harmed or how many individuals must be harmed for the crime to be proven or for it to meet the gravity or seriousness threshold that the court requires. So these are some of the challenges that we would face with that crime, but I believe it is a potential crime that could involve environmental damage. Another crime is the crime which prohibits intentional attacks against civilian objects. And here, the court would have to decide if the term civilian objects would cover damage to the environment, as well again as the gravity of the harm that has been done. Yet another article prohibits destruction of enemy property not required by military necessity. With this crime, the court would have to determine if the part of the environment that has been destroyed would constitute enemy property. So, for example, could it be state-owned forest? Could it be state-owned agricultural lands? Could it be state-owned food processing plants? This would have to be something, again, that the judges would have to determine to decide if this was a crime that could revolve around environmental damage. Yet another crime prohibits intentionally using starvation of civilians as a method of warfare by depriving the civilians of objects indispensable to their survival. And here we would have to break this down into many constituent parts, many thresholds that the court would have to determine have been met. For example, would destroying fields necessary for growing food indicate destruction that would lead to starvation? What percentage of the civilian population would it have to impact? Would you actually have to prove actual starvation? If so, to what extent would you have to prove starvation of the civilian population? So these are some of the challenges that would be faced in taking a broader lens to these crimes, which is what I think we need to do. We need to look at them in a broader perspective than what perhaps has traditionally been brought to bear when looking at such crimes. And of course, proof of these crimes depends not only on how the court would interpret these various terminologies, but also the sufficiency of the evidence that would be provided to prove the crimes. Of course, my office has a duty to act based on a reasonable belief and to make arguments regarding the law and the facts based on that reasonable belief. So before we would ask the court to consider these crimes, we would have to determine what our position was based on good faith understanding of law and facts. What was our position in relation to this terminology? What was our answer in relation to all of these questions that were being asked? Only then would we be able to move forward to the judges and put these issues before them. Now, for all of these possible crimes, even if the judges were to find against us, in all of these instances, of course, evidence of environmental harm can be brought forward in our cases as context within the charged crimes occurred, and perhaps as aggravation of the actual harm that the court was willing to accept. So I believe if we take this broad perspective, this wide lens to the legal framework of the Rome Statute, there are crimes which could be charged that would revolve around environmental damage, depending again on the sufficiency of the evidence and the position on the law that we could take in good faith. Thank you.
Thank you so much, Brenda, for identifying few legal avenues, actually, according to the Rome Statute, which can ICC use to prosecute environmental harm in Ukraine. Thank you for that. And before we come to the questions from the audience, I would like to reflect on one of the challenge which was mentioned by Wayne regarding the mens rea, which we should prove the intent to harm the natural environment. And Victoria has prepared with the team the video regarding the attacks on this Kharkiv Research Institute, which clearly shows this intent. Please, technical team, turn on the video.
В 1932 году здесь был впервые в Советском Союзе осуществлен эксперимент по расщеплению атомного ядра. То есть ядерная физика в бывшем Советском Союзе пошла из Харькова. Таких установок в мире нет.
Знали ли россияне о ситуации в институте? Конечно, знали, и исходя из правил МАГАТЭ, институт обязан был сообщить в МАГАТЭ о том, что здесь находятся ядерные установки. И, как уже говорил Николай Федорович, регулярные комиссии, то есть точные координаты установок присутствуют в МАГАТЭ. И, соответственно, поскольку достаточно большое количество специалистов работают в МАГАТЭ из России, они, безусловно, знали.
Сховище ядерного матеріалу і експериментальна зала ядерної установки джерело нейтронів не постраждали. Саме на місцях їх розташування зафіксовано найбільшу кількість прильотів.
Те, що зробили військові Російської Федерації, ще раз підтверджує, що це країна базовірів, неучів, які не пам'ятають і не знають, що таке цивілізація. Це щось би наповнило якимсь чином оту трагедію, яка була у 86-му році Чорнобильської аварії.
Харківському науково-технічному фізико-технічному інституту були завдані удари великокаліберною зброєю, серед якої були застосовані осколково-фугасні снаряди до артилерійської системи «Піон» калібру 203 мм, а також були використані некеровані реактивні снаряди калібру 220 мм до реактивної системи «Ураган», а також 300-мм реактивні снаряди системи «Смерч».
Постійні погрози з боку країни-агресора щодо застосування ядерної зброї для Харкова, на жаль, стали не просто словами терористів. Саме в місті Харкові розташований Національний науковий центр Харківський фізико-технічний інститут, де розміщена єдина у світі наукова ядерна підкритична установка, джерела нейтронів та сховище ядерних матеріалів. З початку березня до середини вересня інститут піддавався масштабним обстрілам з боку окупантів. І це не випадковість. Так вищому політичному і військовому керівництву Росії достеменно відомо про розташування у Харкові саме цього ядерного об'єкта. Про це свідчать неодноразові публікації у російських засобах масової інформації. За процесуального керівництва Харківської обласної прокуратури проводиться досудове розслідування у кримінальному провадженні за фактом порушення законів та звичаї війни та за фактом екоциду. Неможливо залишити поза увагою розслідування той факт, що інститут відповідно до статті 56 додаткового протоколу Женевської конвенції від 1949 року перебуває під особливим захистом національного і міжнародного законодавства та не повинен бути об'єктом нападу. Посягання російських військ на екологічну безпеку України – це воєнний злочин не лише проти нашої держави, а проти всього світу.
Thank you so much. Dear participants, please raise your hand if you have a question. Please give the mic to this gentleman. Can you please raise your hand?
Which one?
Yeah, this. Great. If possible, please introduce yourself.
I think nobody in this room doubts that the damage to Ukraine's environment has been enormous, and the collecting of evidence is just an enormous task, but it's doable. What is more complicated to my mind is who shall be brought to justice? Who shall be indicted? Is that Mr. Putin? Is that his Security Council? Is that Russian Parliament who sanctioned all this war? Has it been Russia as a state? That's one thing. And the other thing, once the verdict is reached, how to enforce that decision? Of course, Russia will be sentenced. So my question is that possible without regime change in Moscow? Thank you.
Thank you so much for your question. I would reflect a little bit and then probably pass the floor to the speakers. From first point is, I believe both avenues of accountability will be used, is individual criminal responsibility of Russia representatives, military forces, and high leadership, as well as responsibility of Russia as a state, financial responsibility. We will have another plenary session which will be dedicated to the responsibility of Russia as a state. And you will have the opportunity to hear more about this. Now I would like to pass the floor probably to Richard or Wayne and then to Brenda to reflect on the levels of the perpetrators who are being prosecuted. Please, Richard. But if possible, in brief, sorry.
Yeah. Very brief. I think any prosecutor will want to go as high as possible up the hierarchy of command, but under the principle of command responsibility that applies in the ICC, that commander will have to have some kind of effective control to be held liable. So that will all depend on whether evidence could be found that certain levels of commanders had that effective control. And if not control, then you can use principles of liability like ordering or instigating, et cetera, et cetera. So I think there's various options, but it will depend on the evidence.
Brenda, could you please add a little bit more about the level of commanders and the focus of ICC prosecution?
As I mentioned before, we are a court of last resort and complementary to other domestic jurisdictions. So as a matter of course, we would want to look at the higher levels of command, in that many states would be looking at lower level perpetrators. But again, who we would charge and what form of liability we would charge would depend very much on what the evidence is. So as was mentioned, we do have command responsibility as a form of liability, but you have to prove that the person was a superior. Does not have to be a formal superior, but it could be an actual superior, that that person had knowledge of the crimes that were being committed, and they had effective control over their subordinates who were committing the crimes, and they failed to take action within their authority to prevent the crimes or punish them. And this would be an assessment made at each level of command, because you could have command responsibility from the very top all the way down to the field commander who's ordering his unit to commit these crimes or is aware of them and doesn't stop them. The same would be true for ordering, for